Hi, everyone, and welcome to episode 21st of Study With Me. European Union law, this deep dive helps you get ready for your university exams and gain a deeper understanding of the subject. Today, we're doing a really crucial deep dive on the Charter of Fundamental Rights of the European Union, the CFREU. And this isn't just about, listing the rights. Our mission here is to get an exam-ready understanding of its whole life cycle. Its strange birth from silence, its structure, and how it ended up as primary law.
It is a pretty remarkable story, a real legal evolution. I mean, when you look at the EU today, rights protection feels so central to everything.
Right, it feels like it was always there.
Exactly. But the history, well, the history shows this huge paradox. We're looking at a system that was explicitly designed without a fundamental rights framework. And now
it has a charter at the very top of the legal hierarchy.
Right at the top. Same legal value as the founding treaties themselves.
So that transition is the big question. How did the EU go from having basically no fundamental rights to having one of the most advanced human rights documents out there?
That's the key. And if you're preparing for exams, you need to walk away from this knowing two things. First, the absolute importance of Article 6 TEU. That's what gives the Charter its power.
Okay, Article 6.
And second, you have to grasp the tension, the overlap between the Charter, the European Convention on Human Rights, and all the different constitutional traditions in the member states.
Okay, let's start at the very beginning then. The Treaty of Rome. You mentioned a silence. Just how silent was it on rights?
Oh, it was almost absolute. Their early treaty, the EEC Treaty from 1957, it was an economic blueprint, that's all.
Purely about the market.
Entirely. The whole point was setting up a common market, and ensuring free movement of capital, goods, services, people. Fundamental rights, in the sense we think of them today, they were seen as totally extraneous.
Almost alien to the project.
That's a great way to put it. The focus was on fundamental freedoms, but those were just tools for economic goals.
And the assumption, I guess, was that national constitutions already did a good enough job protecting rights.
Precisely. But that assumption, it led to friction almost immediately. Because the European Court of Justice, the ECJ, it had to establish the autonomy of EU law.
And it did that by just refusing to look at national constitutions.
At first, yes. They refused to even consider them when reviewing community acts.
Wow. Where do we see that happening?
Yes, you see it really clearly in the early cases, late 50s. In Stork, back in 1959, the court just flat out said it was not competent to apply national law.
Not our job.
Exactly. And they doubled down on the Nold cases. They basically said, look, it's not our function to make sure internal laws, even constitutional ones, are respected. Community law doesn't have a general principle to protect those rights.
So the ECJ is drawing this very hard line. Community law is its own thing, completely separate from national constitutional checks.
Right. But just after drawing that line, the court takes two monumental steps that completely destabilize everything.
The classic EU law story.
It is. So in 1963, you get Vendend en Loos, which establishes direct effect.
Meaning individuals can use EU law in their national courts.
Yep. And then the big one, 1964, Costa, VENEL. This affirms the primacy of EU law over all national law, including constitution.
Okay, so that's an impossible position. EU law is supreme over national constitutions, but the EU itself isn't bound by any human rights rules.
You've got it. It was a guaranteed constitutional crisis.
And the national courts, they obviously weren't just going to accept this.
Not at all. They saw it as a massive threat to their own democratic orders. And this is where the counterlimit doctrine comes from.
The counterlimit doctrine.
It means they fought back. The constitutional courts in Italy with the Frontini case, and famously in Germany with Solangier, they drew a line.
What did they say?
They said, as long as, that's what Solange means, as long as the EU doesn't have its own adequate rights protection, we reserve the right to scrutinize EU acts. If an EU act violates our core constitutional rights, we won't apply it.
So they were threatening to just ignore EU law?
Exactly. You can imagine the implications. That would have just destroyed the entire project, the uniform application of law, primacy. It would have all crumbled. The EU legal order was on the brink.
So a crisis like that demands a pretty big legal maneuver. The ECJ had to do a complete U-turn.
It was a necessary and, frankly, a very clever strategic move. Instead of continuing to fight the national courts on this, the ECJ just absorbed the conflict.
And that starts with the Stauder case in '69.
Correct. The court suddenly recognized that fundamental rights weren't some external threat. They were an integral part of the general principles of EU law.
So they made it an internal issue.
Precisely. They started policing it themselves. This neutralized the national court's main argument. The conflict was no longer between EU law and national law.
It became a conflict between two types of EU norms.
Exactly right. This internal attraction preserved the primacy principle completely. The court confirmed this in International Handelsgesellschaft. You can't use national rules to judge EU law. The protection is there, but it's guaranteed within the EU system.
So where did the court get these unwritten principles from? What was it looking at?
Two main sources of inspiration. First, the constitutional traditions that were common to the member states, so shared values.
Okay.
And second, and this is hugely important, international human rights treaties, especially the European Convention on Human Rights, the ECHR. That became the key external benchmark.
So if that unwritten system was actually working, why did they need to codify it all into a formal charter years later?
That's a really good question. The unwritten system was, legally it was functional, but it had two big problems. The first was visibility.
Meaning?
Rights that just come from case law are hard for normal people to understand. They lack the democratic legitimacy of a negotiated text. You can't just hand a citizen a stack of court cases.
Right, you need something clear.
And that leads to the second point, political clarity. As the EU's powers grew, people wanted an explicit black and white guarantee that their rights would be respected, not just a promise that some judges would figure it out.
So codification brought certainty and legitimacy.
Exactly. Now, for exam purposes, there are three practical consequences of this whole general principles phase that you have to remember.
Okay, what are they?
First, these rights become interpretive criteria for all EU law. Second, they become the yardstick for legitimacy. An EU act that violates them can be annulled. And third, member states have to respect these rights whenever they're implementing union law, and that last point is key.
Okay, so that brings us to the formal charter. It's drafted, proclaimed in Nice in 2000.
Yes, the Charter of Nice. But at first it was just a political declaration. It didn't have binding legal force.
It was symbolic.
It was. But the political momentum was there. And then came the Lisbon Treaty in 2009. That's the moment it all changes.
This is where it becomes legally binding.
Absolutely. This is all in Article 6 TEU. You have to know this. Article 6 says the Charter has the same legal value as the treaties.
Meaning it's primary law, right at the top.
At the very apex of the EU legal order. Fully binding, fully enforceable by the CJEU.
Let's quickly run through the structure. It's organized into 6 main titles, right? 6 categories of rights.
That's right. They're designed to flow logically. So first, you have dignity. This is the absolute core. The right to life, prohibition of torture.
The fundamentals.
Then freedoms. This is a huge chapter.
Right.
Liberty, security, but also really modern things like data protection, freedom to conduct a business.
Okay.
Third is equality. So non-discrimination,
Yeah.
but also specific protections like the rights of the child and the elderly.
Right.
Fourth is solidarity. This one is pretty unique. It covers social rights, things like workers' rights, health protection, environmental protection.
That's interesting. That goes well beyond a lot of other rights documents.
It does. Then you have citizenship, which is for EU citizens specifically, the right to vote in EU elections, right to good administration. And finally, number 6 is justice. Procedural fairness, right to an effective remedy, presumption of innocence.
That is incredibly broad, especially that solidarity title. But this huge list of rights doesn't apply all the time, does it? There's a limit.
A very important limit. And it's in Article 51.
Article 51, what's the rule?
The Charter applies fully to all the EU institutions. But for member states, it only applies to them when they are implementing union law.
Only when implementing EU law.
That's it. If a national government is acting purely in a domestic area, outside the scope of EU law, the Charter has no jurisdiction.
That must be a tricky line to draw in practice.
It can be, but the ECJ was very clear in the Eckeberg-Franzen case. The court said the scope of the Charter coincides with the scope of EU law. And it stressed that the Charter does not create any new powers or tasks for the EU.
So the EU can't use the Charter to, say, police purely domestic issues.
Exactly. It's a constitutional boundary.
Okay, so let's move on to its external relationships. Even these fundamental rights can be limited, right?
Yes, but only under strict conditions laid out in Article 52. Any limitation has to be provided for by law. It has to respect the essence of the right.
Meaning you can't regulate it out of existence?
Right, and it has to be proportional. So necessary, adequate, and not excessive.
Now, the big one. the ECHR. We said it was a source of inspiration. How does the Charter formally relate to the ECHR now?
This is handled by Article 52, Paragraph 3. It's crucial. It says that for any right in the Charter that corresponds to a right in the ECHR, it must be interpreted as having the same meaning and scope.
So the ECHR sets the floor, a minimum standard.
Exactly. It's the principle of equivalent protection. The Charter has to offer at least what the ECHR offers, but, and this is a critical but, the CJEU can decide to offer a higher level of protection. The ECHR is a minimum, not a ceiling.
And yet, despite all this, the EU still isn't actually a party to the ECHR Treaty, even though Article 6 of its own treaty says it has to be.
This is one of the biggest tensions in EU law. Accession is a treaty obligation. But the CJEU rejected the accession agreement that was negotiated. That was in Opinion 213 back in 2014.
And the reason was the autonomy of EU law. What did the court mean by that?
It meant the court felt the agreement threatened its own exclusive role as the final interpreter of EU law.
It didn't want another court looking over its shoulder.
Essentially, yes. It feared that the European Court of Human Rights in Strasbourg might gain too much power to review how EU law is applied, and that this would undermine the uniformity and the unique constitutional structure of the Union. It's a very protectionist stance.
It's incredible. It's the same fight for supremacy as in Costa, but now it's being fought on the international stage against another top court.
It's the same underlying theme, absolutely. Safeguarding the autonomy of the EU legal order.
And finally, what about the relationship with national constitutions? The very thing that started this whole crisis. What does Article 53 of the Charter say?
Article 53 is the compatibility clause. And while the Charter respects and is inspired by national traditions, the EU legal order ultimately wins. The CJEU made this clear in the Maloney case.
What was the takeaway there?
That a member state can't use its own higher standard of rights protection as an excuse to ignore a uniform EU law, like the European arrest warrant. Primacy and effectiveness of EU law come first.
So it's inspired by national law consistent with the ECHR, but at the end of the day, the CJEU is the one in charge of how it's applied in the EU context.
That's the bottom line.
This has been a fantastic deep dive. We've gone from that initial legal silence through a near meltdown to the clever judicial solution of general principles, and finally to the solid binding framework of the CFREU we have today.
To just boil it down for exams one last time, remember Article 6 TEU, the Charter, has the same value as the treaties. Remember the scope in Article 51. It only binds member states when they're implementing EU law. And remember Article 52.3, the ECHR is the floor, but the CJEU can always go higher.
It's a system that really had to fight for its own existence, step by step.
It is. And let me leave you with a final thought to mull over. Article 6 TEU still says the EU must accede to the ECHR. That's a legal command. But the CJEU's Opinion 213 shows it will fiercely protect the autonomy of EU law.
So they're at an impasse.
A complete impasse. So the question is, what political or legal trick could possibly break this deadlock? If the autonomy principle is non-negotiable, what mechanism could ever allow the EU to actually fulfill the mandate that's written into its own founding treaty?